And the Lord will all convention there. And earlier, definitely, this is second is statute. This was prepared to include it. And also, we will get paragraph.
Which paragraph?
A few sentences of paragraph. Paragraph 27. Yes. The next part, the part. This court ought to recognize the distinction between minority.
Paragraph 27 is something else.
Paragraph 27. This part of the decision is binding, at least in this case, that is their argument. I cannot be the over to draw something. In this case, what was actually decided cannot be undone. They are told repeatedly. It will produce an intolerable state of affairs. This court would be prejudiced. This court would recognize the distinction in the minority of the shareholders for the parties and the reviewability of the application of a case. Between the parties, even a wrong decision can operate as custody care. This was the convention. I am not left with that said is referring to referencing the paragraph 36, paragraph 36. Yes. Paragraph 36. In currency versus etc. I have observed that the fundamental principle is well established that a decree passed without legislation is a nothing, and that stability is set up whenever and wherever it is to be enforced and developed, even at the stage of execution and even in collateral proceedings. The decision, the defect of the decision, whether it is peculiarly territorial, and whether it is in respect of the subject matter of the action, like the very authority of the court to pass it immediately, and such a defect cannot be.
Now, which of these will apply in this case?
Here, I'm emphasizing that if there is an error law, and error law is
Nullity.
Error, yes.
Error of law can't be nullity.
Whether apparent on the face of the law, as it had two cancels. That an order is a court is free to us. It is not my rights, but because of the restoration, so the errors of if a judgment does not constitute a residing data, if a judgment does constitute a residing data, it constitutes it cannot be reviewed. If it is a residing data, it cannot be reviewed and all. So, and the judgment is not a residing data, then if it is initiated by errors apparent on the face of the plan. And error apparent on the face of the plan is always a legal error and not a factual. And CPC, Order 47 rules follow the CPC. In addition to error apparent on the face of the record, but takes notice of another factor. That is discovery of new facts, etc. And that is faced by legal vaccine. So a court is free to work. And by erroneous decision, you can find the parties. And the purpose of custody data is to not allow a party, if there is a minority to assert the truth. Truth has to be, untruth has to be accepted as truth. So this custody data has to be construed very strictly. That is it. That is one of the fundamental principle. And order 47, other than legal error, the only exception is the only other ground on which a review can be sought is this. And taking order 47, 2166. Yes. And after any person considering himself agree by a single order from the exercise of the case. And who from the discovery of a new and important matter of evidence, which after the exercise of due diligence was not within the knowledge or could not be produced by him at the time when the decree was passed, or overpaid, or on account of some mistake or error, apparent on the face of the thought. So the court can only entertain the other law only when discovery of new facts, etc. And otherwise the court, once a court has passed an order, it cannot correct it subject to one qualification that the court very irreversing. In irreversing, the court said this. What determines or what is paramount is constant or constant order is not in the open form. Then the court cannot make any arbitration except some grammatical or technical mistake. And in the court, there's a concept of locus procedencia. After passing an order, the court may feel, judge may feel, yes, I made a wrong. What the court is required to do is to be noticed to the parties, and the order can be completely changed. And then a court can completely change, but the party doesn't have that power. I don't say the appropriate word. That right is appropriate word. A judge can, after pronouncing the order, signing it, authenticating it, and now uploading, everything is done. Everything is done. Your lordship finds that your lordship has committed another. And then in this case, your lordship can completely change the order, completely annul the order, issue an entirely new order. Everything is permissible. That is called suo motu.
That is in the case the court finds this.
Yes.
Can't be any request of the litigant.
I don't have. I can only convince therefore, here the court can correct it on a factual error can be corrected by the court. Factual error, unless a discovery etc. is taken here, cannot be sought to be corrected by the litigant. So therefore, the litigant has to suffer. And unless there is a provision for correction by appeal, the litigant has to suffer. Therefore, that is not the consent that the High Court. We are justicia rewards number one. We are justicia rewards zero. Even if ever should for justice be done. But that is not the actual meaning. We are justicia. We are the authority of the court. The authority of the judicial finding decision. Also, I don't know. It should be given effect too. So that is the meaning. So therefore, that is the reason why I cannot refer to the Story or other authorities and say that there was a concept. The student the concept of the doctor student has to be applied very strictly, and it is for them to establish, not me. I cannot formally not legally incumbent the patient. The burden of proof is on them. I don't have to establish that I am not authorized to be there. More that they have to establish, going by the concept of the opinion that the omnia sunt idam corpus, idam qualitas, idam just, idam cosa peteri, idam addicio masanaram. That good maxim unable to recollect without speaking. So therefore, the burden is on them. Yes, Dhanumara is barred by the doctor of speaker, not me. Because now I have to take to myself the job to convince your lordship. Because in the lordship, because cannot always plea, the court can this. Because a question of the civic exam is concerning the jurisdiction of the court. So the concept is so motu, I don't know which is one correct. Motu, motu, you, I don't know which is one correct. I see both. Yes, and that is so spontaneous in America. So the court has all the power that comes from the maxim. Controllers, addictive, consider so the lordship has the full power because the court, what was it called? The court was Sphinx. If our law can be traced to doctor, the ability doctor, entity pattern because it is factor plus e plus constituting plus anjalaya. So the continue to actually our common law can be related to the normal common law was around completely factor and being getting during the Ghenti's time. And the Ghenti pattern just copied Justinian and Justinian consolidated all the legal literature of the classical common law, legal literature of the Justinian. Sorry, not Julian, Justinian, completely pattern, then came about. I am referring to Wittgenstein and Chief Justice for Communities Law Solution. Actually, the law was a disciple of Wittgenstein, and the communities, possibly communities, Chief Justice for written on the writings of Wittgenstein. So now, therefore, the whole burden is here on them. I am not about myself the burden because you have also raised the issue. So therefore, now I take your worship to ever say the other way. I take your worship to
Which proposition?
The proposition is, yeah, there is no established against law. That established against fact, and that established against fact also is that has to be construed very strictly, and if the entire cause of action is finally adjudicated, then only the established comes. Yes, because this and the question whether established is an established or not depends upon the composition of the court. Composition, the classic term is Texas of King's case. So, a lot of exclusive jurisdiction, are completely adjudicated issue of marriage or constructivity, marriage or constructivity. Then alone the doctrine of established arises. This court, on the ultimate utility is not a court of exclusive jurisdiction. Nothing on the facts has ever been agitated. There will be other ways, Swami Samathan case. The Supreme Court went on to pronounce upon the notification and the explain what has been issued in Bonnet. The last sentence of the order says that without any discussion, the order says the parties are legally to agitate other issues before the DRT. So, they brought it in whether it is DRT or the Supreme Court, that issue was not discussed. So, therefore, this judgment it comes from the Supreme Court case. No case for interference of the Constitution has been set up. There will be no relevant repetition, same is accordingly ordered to be dismissed. Pending application, even in stand close. Needless to observe.
Which order are you reading?
No, I just passed. Last sentence, very last sentence. Needless to observe. Pending the petitioner otherwise will be liberty to pursue his remedy under section 17 of the Surface Act in accordance with law. So, what this judgment does not constitute any estoppel. For an estoppel to come to the doctor estoppel.
No, but this is you succeeded partly by this prudence is very ratified. Not verified.
My attempt is to fully succeed. Because this is asking.
That is the next round before Supreme Court you made.
Many of lordships, even if your lordship is deciding everything, when your lordship once your lordship meeting this issue, my government become easier.
No, I told you even when you argued the first petition,
Yes.
that you had all these conditions come in your first petition.
Yes.
Probably I would have allowed it.
That is therefore.
This is the 25th
Not immediately people might mistake me as an advocate. Not immediately I always say, even in this 1,000 times, I'm there with 1,000 times to me. And if somebody asks me that the saying, yes, a common saying, the Lord drops of water follows a stone, not by force, but by persistence. When you are right, when you decide how you to be persistent or not, you must ask oneself that yes, are you right? Are you ethically right? Are you morally right? Are you legally right? And all this
the answer is you are wrong is not pursuing the inverted agree with that.
So now my conviction is I am legally right, I am morally right, and ethically right. To stand up and say no, in polar hands, I am here with 1001 times. Therefore, there is no element of estoppel. And I take your lordship to the economic.
And this order also said, this decision, however, left unsaid something which we have explained here in above, while construing the terms consistently to prevent undermining of the rights that one central enactor confers by others.
Yes, that's what your lordship has said. Your lordship has said. Yes or no, I take the. I not the PDF copy. I give PDF copy. Here. I have copy. And I give PDF copy. Yes. Paragraph 95. I'm reading one sentence. Yes.
This is 1886.
These are many of these books are permanent edition. First, there is a permanent edition, and the revised constitutional law is also a permanent edition. It is not named as permanent edition, but revised as only the revised by work. So it is a permanent edition. So yeah, your lordship finds because your lordship there is a modern law. Legal magazines. Also, legal magazines, I have learned from Martin Lawrence. And there are now a whole lot of things have been added. And that book has now ceased. The standing glory. So, therefore, it is advised that, it is the book is not allowed to be revised.
This is very
95. Sorry. Paragraph 95. But it is said, established by Bedi, conclude only questions of fact decided and not questions of law. Now I take your lordship to let me first take your lordship to Chief Justice Court at page 88. Chief Justice Court, because these are the latest authorities. Justinian, then Henry Carter, then Lincoln, then Chief Justice Court, then Blackstone, and our great Raspberry. These are the great commentators. Yes. Middle form. Yes. Page 88.
Yes.
In concerning the complaint of Lord God, etc., concerning the multiplicity of suit. So, Chief Justice Court was against multiplicity of proceedings. I am also against multiplicity of proceedings. That's why I said, there shall be only one court, that is civil court. Even 226 was understood. Around the 226 is a mistake. But because the constitution came into existence, we have only.
That's why you file 25 remedies.
No. It is not my fault. I always say no humility, I should not be mistaken. No humility. This guy was not as a going intention. I am using that anti-magic modified just Vivian was not as going in and time for repentance was that was latest or respect latest also.
You are positing upon the
there is a saying, but I may be mistaken. Rare is human. Receiver rare is diabolicum. What is human? There's a repeat.
What do the appellate court has made it correct?
I take your worship to Jesus is called.
Which paragraph in this?
Page 88 along in the middle part. I just mark and keep your worship. Just give me 1 minute, sir. I just mark it. One. I will mark it. Not yet, just one line marking. I will read one more sentence before that. Because all my contention is each cause of action has to be considered distinctly. Distinct. That is also coming over one sentence before that I read about one sentence before. Yeah. Recovery, I will read about 2 sentences above. Or from the beginning of that page, that was the case. Okay, from page 88 was the last sentence. The God very governing. Worship of the Lord?
Yes.
Distinguished there between what operates by way of power, your future recovery for the same day, and what by way of struggle. That was the case of a mere recovery, rejection A made without title arrest, and the plaintiff might, in respect of possession or other varying circumstances of title, be entitled to recover at one time and not be so at another. And it is not the recovery, but the matter alleged by the party, and upon which recovery proceeds, which enters the estoppel. Recovery of itself in an action of trespass is only a bar to the future recovery of damages for the same injury. But the estoppel precludes parties and release from contending to the contrary of that point or matter or fact which having been once distinctly put in issue by them or by those to whom they are privy in estate or law has been on such issue dwelling, solemnly found against them. In considering the complaint of Lord God, etc., concerning multiplicity of suits, which can come to no finite end. Interesto, Republico, finish. Finish.
That's not here.
No, that I have said. Okay. Interesto, Republico, finish. Can come to no finite end. The Lord Chief Justice says, neither, however, would a workman and gentleman in a real action operate by way of bar to future actions of trespass or bring the parties to the finite end wished by the Lord God, because there may be, notwithstanding the verdict and judgment, in a real action, even that which is most conclusive upon right, I mean a record right itself. A right of possession derived under the offer of inheritance which is simple, or those under whom he pays. This may enable the plaintiff in trespass to recover for an injury to his possession done by very person in whose favor the absolute right of property shall have been so affirmed in a real action. A gentleman, therefore, in each species of action is filed only for its own proper purpose and object, and no further. The judgment in trespass affirms the right of possession to be as between the plaintiff and the defendant. In the plaintiff at the time of the trespass commitment. In the real action, it affirms the right of a freehold of the land to be in the demanded at the time of reform. Each species of judgment, from one in an action of trespass to one upon the writ of right, is equally conclusive upon its own subject matter, by way of power and future litigation for the thing thereby decided. Establish an odious concern. See, this is himself says, establish an odious concern. And it is a concern, and therefore it says, when there is a doubt, then there is no stop. If yes, distinct course of action, and why distinct course of action, the question arises. Whether it was decided whenever there is any doubt, I take your logic to the that particular para. When there is a doubt, when there is a doubt, when there is a doubt, then the question is there is no response. When there is a doubt. Yes. 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 I did the middle listen. Am I taking your worship to page 55?
55, 95.
55. That is our that is another chapter. Yes. Ordinarily, a degree in equity is in fact known as a matter of law. Rendered upon the merits when not qualifying words such as without prejudice are used. Still, where an answer in equity set of various matters is defined. Some going to the merits of the case and others not. And there is a general degree of discussion. The degree would not bar another action for the very same demand because of the uncertainty. Whether it was rendered on merits, unless the uncertainty was entirely removed by evidence. Dismissal of a bill, seeking relief in equity, in respect of an instrument on which a party can sue at law, is no bar over to an action upon the same instrument. Though the decree does not state the dismissal to have been without prejudice. Every lawyer, whenever we move about your ways, say without prejudice, so like this is controversy doesn't arise. The dismissal merely means that there is no equity in the plaintiff case, and a suit at law upon the instrument is not inconsistent with this. Then another aspect is finality. Here also this kind. The judgment purpose should have been final. We have seen that a penal decree or a judgment or a decision upon a motion in the course of trial cannot subsequently result if the case goes no further. In precluding the parties from throwing the matter into an issue again, the case must have gone to a complete termination. This is my pocket book. The case must have gone to a complete termination, so that nothing more is necessary. To settle the rights of the parties or the estate of those just if Bernard Trivedi had defined this thing. If everything has been concluded, all properties have recording proceedings have been finished, everything has concluded, then maybe the decision had this concern in mind, answer all right. There also Bernard say nothing is done contrary to a statute. The doctrine already applies, and whatever has been done has to be undone. And
how will every legal action be termed as nullity?
If everything is done contrary to law, they are not abandoned on the basis of
a nullity and an illegal decision.
No. Suppose a fraud doesn't mean nullity.
Correct. Because it unravels everything.
No, common perception is none was bar only makes something voidable. But suppose somebody I am sure that my property is taken process because notice to me, it doesn't affect much of our emotions. On the contrary, fraud is something which when it only makes voidable. Still, fraud is something more offensive than a violation of principles of intelligence.
Correct.
That is our human nature.
You're right. And if fraud is proved, it unravels everything.
Yes, yes.
From the lowest judgment to the judgment.
That word comes Jesus is called.
Correct. From the lowest court to the
Yes,
highest court,
yes.
it is shown that it's something obtained by fraud.
Yes.
None of this
But the all, suppose 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 my staff is probably signs my signature, no money. Tomorrow I rectify communist rectify mandate bravery, so the doctor ratification, an illegal act, a fraudulent act. I am capable of rectifying by blood, on my signature, do a check. But that civil consequence I am capable of, but criminal consequence I don't have. Because when a crime is against the state,
society.
king, the concept is against king. Society, obviously society, the democrat is against society. That's why the criminal law, the conviction of the criminal law is not even a premise, so it's still called not even a premeditated. That is the this is what we are academic. Yes. Yes. This is the theoretical academic. A judgment, an order and conviction. This I believe gave me the topic I would like Lord Lenin argued and lost. Lord Lenin was a lawyer, I think. Because I think Lord Lenin, the public school, I don't remember.
But this is all in the context of admissibility under the evidence side.
Yes.
So we have similar rules in 40 to 43.
Yes. We are the first one to make registration. We make it, all those were great for India only for first time. I don't think they don't even have a contract back to them. When the government of India, the government of India was taken over by the British power, the crown, all registrations were made. And before that, only United States has some registration. Even though very few legislators, very few statutes were the major source of law is common law. Then some elements.
Even in conviction, you can really take note of the fact that there is a criminal crime which is entered as nothing more.
Yes.
Under our 40 to 43.
But in England, it was not even a prohibition. Now, maybe like in the 1920 or something.
That is why even if there is a criminal court judgment, the motor accident case, you have to still independently prove the negligence.
Yes. Because the concept is custody data, you apply the doctor custody data to apply the party should be seen. Cause of action should be seen. Cause of action should be custody data or either actually or constructive. And if just opposite the concept of custody data is residual values, doctor residual values like authority, no limit. So if I am not the party, I am not bound. I can be bound in a proceeding where I am not the party, only whether a representative proceeding. Or who right? And therefore, that is why not immunity, all creation difference are the thing. Why? Because who has got the authority?
No, but declarations are given.
Declaration, I think about this is judgment is wrong. A declaration or a status, title, in a case between a husband and wife, but the divorce is landed. It is a judgment is wrong. And that parties can take advantage of that. And when the divorce is rejected, there is no change of status, then judgment is lost. So the concept of judgment in wrong is not in the sense that it is not that in a strictly sense, it is not even correct to say they are wrong. Because only means that that parties can take advantage of a judgment of his development. That is all. Now, coming back to the judgment should not be final. Then I take your worship to paragraph, maybe only two sentences of the paragraph, please. Paragraph 5 and page 57. Yes. So, there is no, the doctor of Srikata, no application, there is no finality termination of the proceeding. That even after these petitions were filed, they are finally put by property for auction. When you say property for auction was put, when the property was auction was put.
So according to it being a fresh construction, you can challenge it.
There is no necessity. Property was last, property was put on auction. Auction notice issued. Even the matter is because the lawsuit issue notice. So the concept of patented dictate otherwise this is required for there is a minority. Multiplicity of proceedings. In what scheme I have against multiplicity, but today there is a scenario where there is no option. Because now coming to paragraph 55 at page 57. In the next place, the judgment should be enforced at the time of other supplicant. If the question is still subsidies and the judgment in question suspended meantime, there is no stop. Yes, first paragraph, finality. Finally, it is the essence of this, as indeed of every other kind of establishment, that the subject should be subject of it should be settled. Suggestion above made concerning dismissal of this iniquity may be enlarged and not broadly laid down as applicable to all judgments, decrees, and sentences, that it is doubtful, either from the record or from evidence designed to explain the same, upon which several issues, the judgment, victory, or sentence reader, the subject is still at large for further.
Where is page number 37? 37 onwards. This is the question. The first inquiry now must be what is the legal conception of a judgment? Does a judgment necessarily create an estoppel? The general answer is yes. This is page 36. Now, where is page 37?
The judgment legally is fired. Yes, it's only going to stop.
Where is that? 37.
Nobody can dispute about yes. Yes, 36.
From 36 last paragraph.
Yes, 36.
First inquiry.
Yes.
Do you have a copy of it?
I pass on.
Yes.
Yes.
First inquiry.
Yes. I read from my book. The first inquiry must be what is the legal conception of a judgment? Does the judgment necessarily create an estoppel? The general answer is yes. If it results in destiny, no, if it is not. I have that.
Do you have a? We can read it then.
Yes.
No. I will not.
Yes, but now everything is there, but now there is some confusion. Everything is there.
Take page 37. Who has written this well said?
I will.
Then now come give the answer of this. This is the even before seeing this, I asked you come to paragraph 36. I did not see your book. Today I had marked it myself. What is the answer to that?
So, if a judgment wants to specificate, then only we like
necessarily create an estoppel? General answer is yes.
Yes.
If it results in res judicata, no. If it does,
Yes.
yes.
So
What is the definition of this?
What my convention is the entire sofa does not constitute res judicata.
But where is the discussion in this? Where is the discussion in this?
Yes.
I will give this to you.
The Russian is not like I can give it totally.
No. Where I just wanted where this specifically is dealt with. If it is res judicata, you are gone.
Yes.
Now, what is the answer to that is that?
For the res judicata to apply, I think it's a channel also. For the doctor res judicata to apply, then the court should have.
Right.
The court should have.
They must have
the exclusive jurisdiction.
Certainly, that Cook would have said about that in
No, yes. This is what that's a Kingston case. I think the person that was. That's just a Kingston's this one. There's a reverse Kingston case is amazing. I think I'm not sure. Then at page 76. 76. With regard to concept of a silicon to apply, simple about the link, simple it is the cause of action should be the same, the party should be the same, the cause of action should have been decided on the and the court should have the jurisdiction. So, court of exclusive jurisdiction. Yes. With regard to cause of action, what you call phase everything. With regard to cause of action, this includes every material which is necessary for to make it to prove in order to succeed in its action. And everything which is not proved gives defendant an immediate right to judgment must be part of the cause of action. So cause of action is not law. Cause of action is a pure fact. Yes. And the foundation of an action has been stated to be those facts which it is necessary to state and prove in order to maintain it and know this. It is sometimes not easy to say whether an action is founded on contract or on force. Thus, whether possible, for an action against a company or person entity caused by a negligent act of its PSN on the part of a servant of the company, it was held that the action was founded on contract. As the proof of the contract that is later taken was necessary material fact in the action.
Now come to page 80.
The field 1%. So therefore, in a court, that I have ever taken is an immaterial. But the conclusive effect of the judgment in one action upon the subsequent action between the same parties depends to a considerable extent upon the answer to the question whether the same evidence is or is not necessary to maintain both actions. So when I have a contract, if I have to establish that I have the passenger,
Now come
in
to
law I
page,
don't have a government responsible.
Right.
Yes.
now come to page 80.
Yes. Yes. Finally, the elements.
Finally, yeah, correct.
Yes. Finally, the elements which in a single case are generally speaking necessary to establish the clear reciprocal has been thus stated. Every opportunity given to all parties.
First.
Yes, every opportunity given to all of the parties to make out their respective cases. Secondly, a tribunal perfectly competent to decide the issue raised. So here, the High Court is not thought of. The law is not an instrument. You are not exercising the prerogative. The logic is not exercising not single matter.
Correct. Then you go to the DRT.
No, no, civil court.
Go to the civil court.
Yes, yes. In fact, one of the matters in Bombay, well, this is the one referred to civil court, that repeated me and all. Yes. There will be distinct issues. There will be distinct issues. Or a distinct issue between the parties. So, what are these distinct issues? So, it has to be, they have to establish that distinct issues. And that has got to issue a stop. So, unless there is adjudication on merits, and unless something is, but supposing tomorrow this court had the environment, MSN, you can't hold that. No. I'm bound by that. I'm bound by that.
You will also be bound if I hold that you are not entitled to benefit of MSCP.
That also yes. That also yes. But if that decision on a pure dispensation of law.
Correct. In this case, your forum is an appellate forum.
No, the difference is if on a factual mistakes appears a continuation of the object proceedings.
Correct.
And I can bring all convention in appeal.
Surely.
Yes. But in review, I cannot hold
But
that.
actually,
Only
I'm asking you, what prevents you from filing an appeal? Why are you not filing an appeal? You will have another forum to argue all these things.
I take your lordship to Andhri.
One second, you just come to this.
There is distinct issue. Distinct issue linked between the parties. Both a valid and final adjudication upon the issue. All issues are raised.
Correct.
So which is the issue here raised?
You are entitled to MSCP.
No, I just want to say that whether I have an MSME, of course, there
It
is
is
no discussion.
not decided because
There is no,
you came here 24 times.
so there only the court cannot, at the very threshold, give the meaning. This is my case, I can you can claim earlier. And if I come here, I can be denied even in pursuit of God. I think God has relied on some judgments. Where somebody was accused to be with your accusers and bail. And the concept of accusers has more limits. There is no accusers, the principle of accusers, the Latin maxim is, we never purpose. Renuntiare, we proso intellectum.
I did not say anything about acquisitions or waiver.
No, that is not.
You are probably referring to the judgment in Krishna Kumar.
Yes. So, there's a concept of renunciation. Renunciare, we proso, we is no. Pro in my favor. Intellectum is in. God has to do something in my favor. We never purpose renunciare. I have a freedom to renunciate. And the renunciation has, I have not come up with the whole world that I have renunciated. And that is the number of private one.
That is because you gave an undertaking in that particular case, saying that I am withdrawing all my convictions and I will pay
there is no issue of one. My consent, even in favor, that is not problem seeking. But a statutory duty is not about one.
Now, in this 7 principles laid out, which according to you is attracted in your case? What you are reading?
Here.
Not 7, 5 principles.
Everything is nothing else. None of the principles apply.
By same parties. Or with jurisdiction.
What is jurisdiction about this? Is what is the logic exercise of the discretionary jurisdiction?
Then why should I, in that case, why should I answer these conditions?
Then your logic can really make it in civil court.
You are already there before the civil court. You are already there. There is no court where you are not taken there.
If I may say out of record, I have an association with National Law is Campaign. One of the agenda is restraint of the restraint of the civil court.
You don't say agenda, you say objective. You say objective, you don't say agenda. Actually, agenda.
I always tell myself, I cannot even say long, finish. Probably a valid and final education or policy.
Why do you say it's not a final education?
The issue of sympathetic demand, they issued a first notice that finality in the entire issue, the Conservation has come to an end. The entire recovery is complete and everything is over. The notice of the doctor finality comes. Recovery go, puts it in the geo. That is only a public policy. It is only in the interest of the public. There shall be a finality litigation. I stand for that. That is because there is no any litigation, the public will serve. And the individuals will serve. The more the districts and the pro, individual person. So therefore, that finality is not the intention of this company considered authority. And how the Australian government either way is children in school. Therefore, this is only the private destiny.
Not only that, come to page 81. I think that will answer everything for you.
Yes.
81, your underlying question.
Yes. So that even if the formal proceedings were interlocutory, then the court decided an issue between the parties, which was within its jurisdiction. The same cannot be raised in a subsequent proceeding between the same parties. And though the matter may not strictly be speaking reciprocata, an attempt to raise such an issue will dealt with frivolous and vexation and abuse of the clause of court.
There you are.
Yes. Absolutely. Stevenson was accepted. Yes. On the other hand, mere interlocutory order not involving any judgment upon the rights of the parties does not work as an estoppel. Yes. Therefore, may not look at the issue as estoppel. Yes, I am out. Whatever is okay. Order versus non-ahead. Yes. Even this is coming up. Yes. I don't know how to pronounce it. Sasya. Yes. So, Mark. There's one more. Yes. Then the concept of transit in prejudice is discussed. Transit in prejudice and the cause of action. Cause of action is a disputed evidence. Because it is unlawful, we are not able to prejudice in the court. Cause of action is a disputed evidence. And it was very close under adjudication. It transform into something else. Yes. Modern versus Norway has been extracted. I take your worship to paragraph page 295. Page 295. Page 295.
Yes.
So far as in this opinion, I have used expressions estoppel for non-judicial and issue estoppel indifferently. But therefore, turning to the subsidiary issue, which arises in the second appeal, it is necessary to distinguish between them by reference to the careful terminology used by law in modern versus modern. He said, the particular type of estoppel relied upon by the husband is estoppel for non-judicial. This is a generic term, which in the modern law includes two species. First species, which I will call conservation estoppel, is that which prevents a party to an action from asserting or denying as against the other party the existence of particular conservation, the non-existence or existence of which has been determined by a court of competent jurisdiction in previous litigation between the same parties. So we don't look at there is not even there's not even one word about the facts of the case. In the judgment of the Vishnukumar also, in my case also, there is not even a word about the facts of the case. It is just attend basically copying of the agent. There is not estoppel, issue estoppel, possession estoppel, any form of estoppel. There can be no estoppel unless there is a discussion of that. Because the concept is socially data, it's algo micro, it's micro algo, it's spectral curve, it's curve. What the code can say black and white. For what white black is something concerning a fact. The code cannot make no which was white into black. No. What is bound by the law? What are bound by the law? Let's know it. Just know it. What is Shruti bound by? Administration justice according to law. Therefore, the custom is estoppel. Whoever speaks of estoppel cannot speak of estoppel on a pure question of law. Pure question of law. And there cannot have been much instances like this in the past because cannot protect the last case. Was never used to pronounce upon issues which was not proposed. The problem with the court is that the court enjoyed to pronounce upon issues which were not before the court.
No, you are in appeal against the Bombay President.
Yes.
And it is your contention that the even without you apply or not, the bank was obliged to extend the benefit to you.
The Bombay High Court, there was no reference to any facts of any case. Simply, there is a question of law whether this is mandatory or not.
Correct. Yes. But your contention is noticed in paragraph 4.
Yes, now, this is the technology of marriage. Let's say we are going to do that. We are not going to do that. The court there explicitly says that we are not going to the facts of any case. So it is an abstract. A judgment was holding that it is impossible for the borrowers to make an application. It is impossible for the bank to identify in sequences without any discussion of the facts. The bank will have a case. The RBI guidelines right from the 2000. Now, I take your worship to this from 2000 onwards, the guidelines for identification of stress is there. Nobody said there is a identification.
So many except Rooney's, the other petitioners did not tell.
Manisha Mehta challenged independent. She was the first one to challenge. That was dismissed. Then the review petition was filed. That was dismissed. Then the first assembly was filed. That was allowed. And because the justice Vijayakanand allowed it, and based on which only Justice Bharat is taken case. Justice Bharat is still on this.
Allowed on what group?
Justice Surya. No, Justice Surya said there is a review petition to be dismissed on the ground of budget. So nothing was decided. There is no budget for restricted, and that is based on the Vijayakanand case. I take your worship page 8. This is of 2002. 2002. Your worship on page 8.
One second. You're reading that?
Page 8 of the
circular.
This is a combination of the various notifications. In fact, it is not complete. There are no notifications. But it contains a lot of notifications. Page 8.
Yes.
Appendix 1. Illustrating list of warning signs, signals, or secret signals that are drawn during the scrutiny of borrower's account and other related account, including the financial data, etc. This notification says the server issued by the Reserve Bank of India, and which has been said in Zavindra's case and subsequent case that there is statutory binding. They are constantly on the banks to identify secrets.
It is held as binding even in prudence.
No, because the moment in air Chandra, nobody had a man did not make it clear at all that it is impossible for them to identify secrets. There is no this, but such a convention was not based, the fighter was never answered. It came out from the thought from the group that it is impossible for the banks to identify sequences. Because there are thousands and thousands of members in it. And based that judgment was challenged in the economy. So there was nothing, no factual discussion, no factual dispute, nothing was discussed in heaven again terms all in common. So that was whatever has been decided is a laws from the right. Your question of law without us. So now laws upon a legal issue without any discussion to facts, nothing of and that was Supreme Court and the Constitution against regards to the paragraph 16. They said, what shall not do it? What should not totally decide the other issue which was before it? Because that is therefore the government has to be understood because the different has.
What happened to the review you filed? You didn't file a review against student.
No, that's about if you file a review, it will be district changes. So we filed a miscellaneous petition. Miscellaneous petition are pending. Because the reality covers the review petition never that never will come. Even the captain will be absolutely. Because the seat of tomorrow, you come to know about that, it's a knowledge chambers. So review petition, no purpose is served. So therefore now, in corner, therefore, what was intended is that the intention is it affirms the notification. It says at the most to speak in their favor. The everything means that supporting everything has come to a finality. Then probably it cannot be reopened. So that scenario is not here. That is an academic issue now. Here the real issues are there. My property, my residence is torn out of my residence. The country is in the case of SAR. In the case of SLI, the office is taken possession of. The residential home at the our commissioner is done only. So therefore that part is not applicable. So therefore the whole issue. Now otherwise the scenario would be I take your worship EDMC. There is no difference between EDMC and here. EDMC came other times. He also came 100.
No, there the entire issues were left open. Entire issues were left open in the previous year.
Yes.
Entire issues have extracted that.
No,
In fact, that is the condition of the bank in that case. Dealt with that. The second last judgment left open all the issues.
But in all my cases also, I have dedicated to the DRP. Now, not 1 second, Menon. I have not dedicated to address the issue. Your Lordship, in this case, they have given the issue to the DRP.
In this case,
in PDFC. No.
I interfered with the
Earlier judgment. In my matters, I withdraw the.
No, because you just read paragraph 31.
Yes. The objection raised by the respondent bank that the petition is not the residing data. Due to the filing of further petition number, etc., and subsequent proceedings in RP, etc., and interview, etc., cannot be sustained. In the petition number dash, the last in the series of petition. This court has expressly left all complaints to the petitioners confirmed. Given the above, none of the judgments I did the problem applied to the tax case. I am on the same position.
One difference. That's the case where the bank said we had applied the benefit to the notification and a committee was constituted. It turns out that
Yes.
there's no committee constitution as required under the notification.
Yes, no single bank has, not even a single bank or financial institution has ever constituted a committee. Therefore, it's impossible. Nobody has constituted a committee.
Now they have to.
Now, I stand on the same thing. Because your lordship dedicated, not your lordship, dedicated the TRP, because the cause of action is this continues. There is no finality.
But on facts, what you did was, you said you are going to withdraw what is there in the DRP.
No. Because I filed the suit in the corporate. Suit is filed. The suit is filed mainly under the issue of terminology jurisdiction. Because in Gujarat you can file a suit for police violence district court. In Bombay, the maximum court is the 1,000 crore is calculated. Here we file a suit. 10% is the copy and 10% of that has to be paid at the very institution.
And well,
Yes, and not see, the other perception is that we are a very litigious society. But India is one of the countries where the litigation is lowest per capita, lowest. Maharashtra is 1.4 per thousand. In many countries it's 30, 100, very high. So the perception is from who put in a suit for.
if they get a copy of Everest or Aristotle, this will be doubled. Because till the judges decide, they make the litigant more
Chief Justice Court said so. Chief Justice Court was worried about multiplicity of litigation. And I will read from the other Chief Justice Court, even the Everest and Aristotle also. There is a other locality, but I am not quoting. Chief Justice committees of laws of India. And
Sunil, there is no appeal against PDMC.
PDMC means, I think I spoke to Mohan Jacob, they are filing an appeal.
No stay.
That is strange. I do not know if it has come up for.
But it is also 1 month back.
I spoke to him like last week, may not get. I shall verify.
but now comes to Washington, now Madras High Court.
That is so.
Madras High Court, they did not discuss much about none of the issues of the section. One word is Madras High Court said the DRP has no jurisdiction because the rights of obligation, look at my claim law, my contention is, since the FSMD Act the notification has creates or contemplates creation of rights and obligations in addition to the common law or unknown to common law or in addition to common law. And it's so far as the Act has not created any forum for adjudication of those cases, the jurisdiction of this inflow is not out to the council. And your lordship has further explained that action of section 13 can be challenged only for section 13 for systems have been taken. So therefore, obviously the jurisdiction of the civil court is not option. And so I'm very surprised here what the DRP can do. The DRP is a regular of limited jurisdiction. It can only do whatever has been especially.
But how do you get over the bar of 34?
Bar of 34 is very limited. I keep out of it. The judgment of the mediation judgment of litigation law. Litigation law and later martial. Because there is no bar because one of the concept is, if I know the concept of actual actual voluntaries, and the right of a borrower and the right of the banker action. If the banker has a right to proceed against me, I have a right to proceed against them if I feel that I have suffered from it. So therefore, the RDDP Act is only one-sided legislation. But I don't actually watch it. The section 19(6) and 11, section 19(6) to 11 was incorporated for those enabling me to file a Congress written statement, etc.
Good amendment.
Yes. So therefore, the enactment which was considered has been now at the minority parties, both parties can ask the all issues to be decided within them. So it's because the jurisdiction is not allowed. And again, I about this issue of outside jurisdiction. The first case when the legislature had to handle this issue was the Excise Act of 1922. And that was first ever federal claim in India. And under the Excise Act of 1922, under Section 66, many question of law, because the tribunal cannot, the authorities under the Excise Act cannot decide a question of law. And therefore, the provision for reference to the High Court opposition, Section 66 was provided. Section 66. And when the Excise Act of 1961, Section 256 was incorporated. Either party can make a reference to the High Court. And now the Excise Act was further amended. I think in Section 268.
What is the court fee? What is the court fee that you pay for? There you don't have a court fee.
3 lakhs, 3 lakhs, 3 lakhs. Yes. As well as
Here, if you have to file it, there should be on the basis of the claim made by them.
yes. But there is one way. Legal declaration, not about this too.
No, even under 25D, our act, you have to, it's market value. If the property is taken, it's market value.
Yes.
If you are charging a notice, it's the value of that.
Yes, right. I know the situation. That issue.
That's why you are going to Madurai and file.
I will discuss the matter between the two. It is. Because that is also. 1, 2, 3, we can be referred to mediation.
There is some chance for a settlement. There will be something in referring. Otherwise, what is the point? Cases where they are opposing truth and nature. What is the point?
Remember, they say, the issue is also the borrowers of the they have all these things. They who wants to litigate? Nobody wants to litigate. But for them to, for the banks and the right institutions to come forward, they go for discussion. The borrower should be subject. At the only stage they come forward, discussion. And the number of matters go on. I have a lot of matters in the RTI. 2016, I came about the RTI work at this. That number of matters was actually more city. Because after 3 years, the entire debt is written off from the financial group. And after 3 years, banks find it a bit profitable to settle the matter because whatever the money is paid is the money is treated as profits. And every bank wants to show huge profit.
Written off. Written off.
In 3 years, it has to be written off. After 3 years, settlement is possible. Assume the property is valued terrible. The debt is 24. I offer a terrible or whatever. So that it is profitable for the bank.
It's that they offer an output, you don't pay that. This is Madurai judgment.
Yes.
That's on the ground that no committee was formed.
Yes. Because the Madurai bench have taken this stand, the jurisdiction issue. By taking your lordship around to pay Mara 51. Yes, but shall I? Lordship have a copy. You have a copy. Para 21. Next, because the next convention that there is an alternative remedy before DRT is outrightly rejected. Since the issue raised in the present petition is whether the bank can proceed under the suppression without formulating the revival.
But anyway, there is something good in prudent. Legally, banks should contend that it's not statutory, it's not going to be followed, it's only to be ignored. That has changed.
That is changed, which is a jurisdiction issue. So the court has said it's a jurisdiction issue. Your lordship has explained it more. Further, the issue is not under the surface yet, but is under the section 9 of the FSMA Act that with the notification of 2015 is not elaborated. So, my attention is I'm relying on prevention and which has been quoted in the other day. The error is a jurisdictional. The jurisdictional error committed by the PRT. Sorry, the authorized officer. And authorized officer is a tribunal. Without any of the trappings of a court. And later also, it will be very, very neat to put together. I'm not going to just refer to the section 13 was the subject. I will not. What is contemplated is creation of a tribunal. And the function is judicial. Not legislative.
Statutory.
Yes, section 13 I will not read it, I will just specifically. Where any borrower who is under liability to central creditor under security makes any demand to the repayment of the secretary or installment thereof. The economic benefit of such a is classified by the security creditor and the norm of economic. So the classification was done without notice to me. If classification was done without notice to me, and the bank was really required to ask the person, that is what the judgment of justice, the speaks about. Gives some proof, but certainly notice was the classification. I only was served with the notice under section 13(2). The classification of the account of section as an NPA was entirely.
No, but you always get a notice. See, 32 remember notice.
Normally, a recall notice cannot issue.
I see that in so many cases.
That is not a statutory notice sent from the demand.
No, that is only the alert given. That steps are on the way. That's normally not a overdue notice. Correct.
And then the recall is recalling the loan. But term loan might have a period that exceeds the point of recall.
See, why should they before issuing a notice, you have every right to respond to it.
When they classify the account as incorrect.
Correct. Therefore, you can say in the reply that your classification is wrong. And which they have to consider under 3A.
No, in my case, we have done it. I think so 13 to my convention, I know one about my convention. 13 to the classification of the account is a civil consequences. And the statutory authority is required to inform me I'm going to classify the account as a then section 3A. If on the receipt of the notice of the subsection 2, the borrower makes the representation, etc. And yes. Yeah, just communicate the receipt of such representation, objection. These are for non-acceptance of the representation. So, a notice, adjudication, ideally I should be taking the opportunity to be heard. Or by considering my objections and communication, principles of natural justice. What you are part of and communication of the order. So therefore, what is contemplated is a function of a tribunal. This is not providing the notification or the FSMA notification. There is a jurisdictional issue, and the notice is void. So the cause of action is whether the notice under section 13 is void or not. That issue was never decided. There is not even a whisper about it. The judgment only deals with Krishna Kumar. And in my case, I have nothing to notice of it. I said in so many ways. I said it so much. My reply to that is, I take your worship to page 73. Page 73, representation number 325 2025. They need to file a formal petition. They need to file a formal petition. You must not the
Which page?
another case. I take a motion to notice. At page number, at page number is 74. At page number 74. That's 74. Message LB XFR infrastructure limited is registered as a dealership.
I got it.
Message LB XFR infrastructure limited is registered as a small enterprise under the MSME and having investment job registration of the MSME. Please note that while notice dated dash, it is declared as the following facilities, etc. Then number 4A. These statutory guidelines provided by the government of India, etc., they declared by the law for the main.
No, yes, what is your reply to the 32 notice?
Yes, yes. This is my reply to the 32 notice. And by the virtue of the judgment of the Swami Samantan, I raised the issue.
But before that, you lost before the single judge and the division bench.
No, if that judgment constitutes a restituted, yes. If that does not constitute a restituted, then we go.
The Eastern route will be the challenge that in Supreme Court, the division bench judgment.
That is dismissed.
No.
SLP file dismissed, review petition file, restoration file, that is also dismissed. The major submit. Initially, there are one company, no, just I don't fully trust you. In Esteban's case, there was one company and a partnership. And a proprietary council. Initially, when SRPC action was taken, they approached the DRT, both of them. Then, when action was being taken, my friend had approached when some of the assets were being proceeded against, they initially approached this court. In both petitions, they were relegated to the DRT. Thereafter, my friend filed a series of cases in Bombay. Bombay High Court said to go back to Kerala High Court. Then he files two petitions here, one by the company and one by the firm, proprietorship firm. It was opposed. And as far as the company is concerned, we said the debt is more than 25 crores, the specific contention. And so he cannot be considered, he will not come within the scope of the.
There is an exclusion. There is exclusion.
There is no exclusion. There is exclusion in the RBI. No, I'll come to the RBI circular subsequently says that after consultation with the government, we are showing that up to 25 crores still the MSME notification apply. Beyond 25 crores it will not apply. That is what it is. Yes. So when we file a counter affidavit to the action, he filed a separate petition saying that challenging this RBI circular saying that RBI could not have put a ceiling. That was about to be dismissed, saying that you should have asked on the other pending petition. Then he withdrew Hospital Liberty to amend the petition. He amends the petition of Esteban Private Limited, incorporating this challenge. Now, both the repetition against the company, filed by the company and the proprietorship, were dismissed by common judgment. Two writ appeals were filed. Writ appeals were where this contention was considered by the and it was dismissed. Against which he files an SLP only against in one company, that is company's case. And simultaneously files two review petitions here. Both the review petitions were dismissed. Detailed judgments, detailed orders. The SLP was dismissed as far as the company is concerned. He filed a petition for restoration, MA was filed. That is dismissed. So as far as Esteban is concerned, and now he is now trying to challenge that 50 crores thing challenge. My humble submission is, so long as 144, Article 144 is there in the Constitution, this court cannot go into this. Number one. On facts, this has attained finality.
And he is arguing only on estoppel.
No, estoppel, certainly on estoppel. He is estoppel. I'll come to the judgments because Seller and Hope Plantation clearly says because constructive res judicata has a more hybrid principle, because civil court jurisdiction cannot be based, it's not a parallel to what writ court jurisdiction. So constructive jurisdiction says that whatever you have taken and what you could have taken at that point in time should be taken. Now, this repetition is a verbatim reproduction of one another petition, except for that a notice, possession notice issued in August is produced. If that is the only eligible, then DRT is the only place. As far as the eligibility for MSME, it is attained finality. This court cannot, my submission is this court cannot touch it because of the Supreme Court judgment on the matter. Inter-party. Supreme Court will be wrong, but we are bound by that. So that portion cannot be done. Now the only additional affidavit is produced now. The priors are the same except for this one, that an additional notice of possession has been given, which is under SurfaceE Act. Clearly, the provisions of SurfaceE Act come in, he has to go to the DRT. He cannot come again, re-agitate, challenge that 25 crores ceiling. That is what submission has, and once he finishes, I'll make my detailed submissions.
Supreme Court judgment, Supreme Court matter was never admitted, was not dismissed or was dismissed for debauch. And the situation was, it was not because it was dismissed. It was never adjudicated on the merits. So, if a matter is decided on merits, which is certainly about by that, let me take your Washington, pre-judge bench of judgment in Florida versus So, if the principle laid down in the law is reaffirmed by the Supreme Court, but paragraph yes, I take your logic to page 43. Yes.
Page 43.
Sorry, para 43. Yes. Sorry, yes. Yes. I take your logic to page 395. 395. So, paragraph 26(1). Because it's a unmarked copy, therefore I have something with version I think. 26(2), yes. 26(1), yes. Okay, 26. From the immediate reading of various statements, we sum up the legal position as such. The conclusions contained by the pre-judge bench of this court in Punyamad and summed up in paragraph 44 are affirmed and reiterated. As the paragraph 44 is to sum up the conclusions of in paragraph 44, page 392. Where an appeal or revision is provided against an order passed by the court, by a court, tribunal, or any other authority before superior court, and such superior court modifies, reverses, or affirms the decision put in issue before it. The decision of the subordinate court merged with the decision of the superior court, and it is the right which subsists, remain operative, and is capable of enforcement in their effort. The jurisdiction conferred under Article 136 of the Constitution is divisible into two stages. The first stage is up to the disposal of the affair for specially for an appeal. The second stage commences if the deemed to appeal is granted and the specific petition is converted into an appeal. The doctrine of merger is not a doctrine of universal or unlimited application. It will depend upon the nature of the jurisdiction exercised by the superior court and the content or subject matter of the seventh page or controlling page shall be the determinative of the applicable to the subject. The superior jurisdiction should be capable of reversing, modifying, or affirming the order put in issue before it. Under Article 136 of the Constitution, the Supreme Court may reverse, modify, or affirm the judgment, decree, or order appealed against by exercising its appellate jurisdiction, and not by exercising the discretionary jurisdiction, disposing of the petition or specially to appeal. So therefore, the Supreme Court is not exercising its appellate jurisdiction, exercising the discretionary jurisdiction, disposing the petition or specially to appeal. The doctrine of merger can therefore be applied to the former and not to the later. An order refusing to specially terminate may be non-speaking order or a speaking one. In either case, it does not attract the doctrine of merger. The order refusing to specially terminate does not stand substituted in the case of the order under current. All that it means is that the court was not inclined to exercise its discretion as to allow the appeal being filed. If the order refusing to appeal is a speaking order, that is given reason for refusing to grant, then the order has two implications. First, the statement of law contained in the order is a declaration of law by the Supreme Court of the Constitution. Secondly,
Yours was dismissed at which stage?
Dismiss at the official stage.
SLP stage.
Yes.
No, I produced men. Now there is no quarrel. Submit. No, no. Let me just clear. There is no quarrel with the proposition that if SLP is dismissed, either with a speaking order or non-speaking order, there is no doctrine of merger. It doesn't apply. I'm fully in support. Now, my friend has filed an SLP, which is produced as R4E along with an IA 1 of 2025. It's in the bundle.
R4?
R4E. It says, heard learned counsel for the petitioners. We do not find any case is made out for interference with impugned order. Special petitioner is accordingly dismissed. And let me just stop it. No, please, you kindly take rest for a while. Now, I'm not pleading that the doctrine emergent. Now, what happened? What preceded this was the division bench judgment of this court. Then what my friend did is file a MA, which the order is on the next page. I'm not saying that there is a doctrine emergent or next page is file an MA, which is we do not find any cases made for entertaining the application for restoration of petition, which is dismissed after hearing the learned counsel petitioner. Misplaced application accordingly dismissed. Pending application, if any, shall also stand dismissed. Then what happened was he files, because in Kunyama's case, what was that? If there is no merger, he can approach the forum next below for review. He approached the division bench for review, which was dismissed. Which order? I have produced that also. It's a detailed order. I'll pass on. Pass it over. The detailed order for Andule, etc. were pleaded and it is dismissed. It's a detailed order.
I'm not taking a side.
No, just you've taken so much of time to do it. Part of my substantial part of my remaining life. Now this finds this court. Andule is discussed, everything is discussed. So, when these two judgments, this order stays, my lord, in my face. The same pleading regarding that bar of 20 men, the ceiling of 25 cannot be considered because that was raised, considered, and decided against my friend. And if any pleading he has not taken of that thing, it should be deemed to be abandoned. Does not give him liberty to take afresh. But in the writ appeal judgment, there is a reference also about this, the pleading he made in the petition. So all I'm saying is, now this is, as far as my friend is concerned, this is attained finality. He can challenge this payment. His SLP against the writ appeal has been dismissed without consideration. But the question remains whether he can file an SLP against the RP order and RP, which I don't know. But then this court at this stage, the court cannot consider the same which has already been considered and decided against him. I'm not getting to anything further because I don't have to, because this is absolute binding on this, and I'll just take my lords to the Cellier portion of the Cellier judgment.
And consider that.
And that
This first round and Spengler.
beg your pardon?
Irrigation, spark.
Yeah, Cellier also it's been so flogged so much, it's almost dead.
Yes.
My friend, what my friend has said about the Supreme Court proceeding.
No, he's saying after the dismissal of the SLP, you came back in a review.
Yes.
There was no merger, nothing.
Yes.
Where these contentions were raised and found against.
Yes. So, my lord, see, the question is, what I said, my lord, and what I did not, has been studied the figured on estoppel. If there is whatever proceedings which are so far as gone, if it results in estoppel, issue estoppel, or some action estoppel, any form of estoppel, there has not been any discussion at any stage about the actual case.
The review judgment considered even the 2018 Federal and judgment.
Yes.
Which I relied on in the earlier case of Justice Rohit Narendran, of also what constitutes res judicata.
Yes, yes.
And relied on that it was dismissed. As long as it stands, how do you make this
No, now, this is that is the whole issue is if some of the actual disputes, conventions, okay, fine, here is what is my contention. I in 2021, I informed them. There is no discussion about a word. You know, the narrator worship to page 64. Because the parties come before a court for adjudication of the actual case. Without reference to the facts, there cannot be any determination. The case is the Udyog registration. This is true.
that you have mentioned in the reply also.
Yes, another the MPSFR, etc., to Anubhav, etc., manage regulatory now, three attachments. Udyog Aadhaar Right, Udyog registration, MD Udyog Limited. So here.
And what do you say about this contention that if you are, because your liability is above 25 crores,
No,
this will not apply?
that issue, I challenge the notification, acknowledge that issue has never been discussed.
Yes, why is my friend saying that? Why is my friend saying that repetition it is considered? It was considered. Yes. No, if it has not been considered, it is up to incumbent upon you to raise it in the writ appeal, saying that this has not been considered. There is no such ground in the. I will come to that also. No, I will show that. No, wait.
I challenge the notification and the notice that.
In page 134 of the writ petition is the judgment, portion of the judgment. 134 is exhibit P17 of this writ petition. I'm reading out from the judgment of the single judge. It is not disputed that the liability in the loan account, which is the subject matter of writ petition so and so, is in excess of 25 crores. Therefore, the petitioners and the so and so are not entitled to the benefit of P2 and P3. Now, this contention was never raised, although the learned single division bench considered this. In his memorandum of appeal, there is absolutely no reference. It is very strange to see. It's only 2 paragraphs, nothing. It's more on his video recording and all, nothing on merits. So he is positively abandoned this. So he cannot be allowed to restore the thing or revive the same contention. Otherwise, the entire process become a mockery. This was, and it says about amendment. It is say no. Please, you have had your chance. he should have pursued this right up to Supreme Court. Once you abandoned and gone on a tangent, you cannot come back and then try to revive the entire thing which you abandoned. That is the entire principle of Henderson principle as well as the constitutional adjudicator. You are bound by it. No amount of Latin dictums and all that are going to help you because this stares at your face.
Yes. Yes. Let me answer that. My contention is notification. Somehow I made a prayer in this petition. We declare that I paid 87. Yes.
No, but there is a finding that it's not applicable to you.
No, there is no discussion. I challenge the notification. The validity of the notification. I challenge the validity of the notification. That issue was not decided. The legal issue wouldn't be a restoration unless it is decided.
See, right or wrong, this court finds that you are not entitled to the benefit.
Pardon me?
Right or wrong, this court says.
No, 25 crore limitation. When I challenge the validity of a notification, the validity the one has to hold that either the notification is valid or the notification
That's
is
one.
valid.
And secondly, you find an appeal against the judgment, against me serving judgment.
Yes.
In which case, your first contention should have been this.
No, who said that issue was never raised? Never raised.
You are the person to raise.
No, there is no determination. There is no determination. There was no. The issue was it was not argued. My friend did not raise the issue that by 25,000.
Yes, it was specific contention on which he filed a petition, which is about to be dismissed. No, in my counter affidavit I stated all this. No, please do not.
Therefore, I amended the petition.
Yes, and incorporated this.
There has to be a finding. Either the cap is valid or not.
There's a finding it is not applicable.
No. There's no.
No, let me just refer to the grounds in the writ appeal. Writ appeal filed in this case, which very interesting reading.
Yes. Let me.
No, man, how much time are you going to take, my friend?
Paragraph 87. Yes.
They copied it.
Paragraph 87. This is the plan. Declare that circular date 17/2016 restricting net completely taking away the benefit of the notification dated 29/2015 from the MSMEs whose crediting with 55 crore is illegal. Otherwise, the MSME Act of this notification and going to the extent that it takes away the rights. Without announcing about how come there is a finding.
Now, he had filed
I can be barred. What is the restricting guideline?
No, he had filed a
I
writ
can be
appeal.
barred in some case, but there is not only finding. Supposing that there is a finding that this notification is void, sorry, it is valid. Rejecting it, I mean, there is either at least an order rejecting my plea, it is not there.
Now, my friend may be right in the end. No, he has to, no, please, when faced with facts, my friend has this thought. He is very comfortable in Latin thing and vague way, but when faced with clear facts, he mumbles. Now, this is may I just pass on. These are the grounds taken under the appeal. Is there a ground?
So what is it?
No, there is no ground. There is no ground at all.
Appeal is a continuation of the proceeding.
No, whatever it is.
Appeal is a continuation of the proceeding. I don't take any new ground. I've taken a ground in the original proceeding. Appeal is a continuation.
No, but anyway, it has been decided against you. Review petition has been decided against you.
It's not a discovery of new facts. Nothing. It is only that appeal is a continuation.
It's not as if I do not know that, but then if you have agreed, but
should know basic things.
I know enough or more than you. I know more about you also. So do not let us not get into that. So Kadumara, please let us not get into that. Okay. I know enough law to propose you. Don't worry. I may not know you, but I may not know Latin action which is absolutely useful in the context. I mean, I was looking for Justice Narasimhan's judgment, recent judgment, saying that you can just throw Latin. It means nothing unless it has any bearing on the facts to be established or pleaded.
Now it is a person accusation.
You made it. You started it.
No.
No, what I'm saying is, no, this cannot go on. I've been extremely patient. I've been extremely patient on my. No, another one. No, I'm at the end of my patience because this has been going on for some time. And unfortunately, courts have been entertaining this. That means which the privilege others don't. Yeah. I rest my case. Same thing.
Yes, I started with Justice Govindan.
You can start with anybody, I'm not bothered. As far as I'm concerned, a judgment is a judgment of the Supreme Court. It doesn't bother me who is the judge. Okay. No, what is I'm saying that is what you started. Exactly what I'm doing. That is why you're getting perturbed.
I am pleased for that.
When you come to facts,
Answer that question. Appeal is a continuation of what they proceeding.
I have no quarrel with that. I have no quarrel with that. But judgment and
he gave me a appeal. I asked the information, so I know nothing. The reason appeal is a continuation of proceeding. They will ask me nothing more. If I don't have no benefit.
Why do I have to say that? I have to know enough and more to beat you anytime. Don't worry. Okay, that is enough.
What else?
What my contention is, this was taken. Even in terms of this is better to judgment. This is better statement says, yes, the borrower has to bring to the notice of the bank. And this is a communication.
But you claim that in the reply notice.
So it was something which was not to the court. And if the court has made an error, or a legal error, not factual. Legal error, factual error, your lordship can correct only on a written petition or on your lordship's own volume. But legal error, your lordship is the whole community cannot adopt this correct. And the concept of to make it abundantly clear, I am out if there is a cause of action estoppel. Cause of action estoppel, as Lord Igno has said in Noddle versus Noddle, a cause of action which is a dispute with evidence, or dispute of fact, when it undergoes a trial, and that process is called transiting judicat. It is not my word. Transiting judicat.
See, in 32541, you are again challenging the MSME.
Yes, same thing.
I'm just concluding. I'm just concluding.
So what is in this 13154?
3154. Talks of that is for filing monthly by 154 notification of old government to auction. At that point of time, challenging the auction notice only the petition was filed. So in the second petition, which none other than the announcement of the first petition, has also taken the contention which he has taken in the exhibit R, RA judgment. Identical contention. The verbatim of the retribution which is not the MSME exhibit. So none of those contentions cannot be considered in this present retribution. The only cause of action is the old order. Only that paragraph 5 and 6 only additional paragraph 3. All other remains the same.
What happened to that?
Now that time of filing the retribution now is not take place. Subsequently on 36/2024, another 2025, we are filing that option notice has been issued. And on 15/7/2025, that option is being held. And this was also communicated. Prior notice was also given that as notice additional documents. DER, R1, DER,
The auction is over.
auction is over and that has been communicated to the surplus amount has been adjusted to the loan account communicated to the 0 pay. So nothing survives in that retribution.
It is 30 please.
One page is like this is a security calendar from the Lord of the emergency. And in that case, I intimate you very well that nothing you reply also said there is not dispute of that I was aware of it. And last year I got as MPA, and in spite of my refusing to take my continuing reply, that I have was. And based on Krishna Kumar, the case of business, against which I filed an SLP from the single bench, that has been applied. That has been applied. So therefore the matter is in now in season of the Supreme Court. And if they came for possession of the selling the property, I chose it before this court.
What is the other SCP mentioned in this 30224?
Now that the lordship has passed an order, and this is my daughter's orphanage. Nari and all was very limited right. And when this order was in the matter was before your lordship, and the matter was adjourned, then it is not before. The order extension is about.
So when was the auction?
15/7. And because of the majority, they say it is typically gold or loan. There is no connection whatsoever with the MSME or anything of that. No 13 notice, nothing will happen this case because it is a gold or ornaments auction. And that is evidence of actually B6. Where like E4, I have got a document which also shows that it is a typical gold ornament. Gold. This it does not form part of the security of the MSME. No, absolutely not. You are asking a kind of look at
Now, against the first judgment of 28 there is an SLP pending.
what my loss?
Against the, you filed a SLP against the single judgment.
Yes, yes, because then the Shoma Japan came, going into the bishop of practical values. So that and all of the weapons of the civil were silent before the Supreme Court in the assembly. And all those who are appealing. He filed a repetition here, he lost.
Correct. Therefore, you have to now wait for the decision in this. I'm not asking for the decision this with the matter pending SLP.
The Japan also means by the convention that during the decision.
No, as far as this case is concerned, when your SLP is pending,
Yes.
how can all these cases be decided here?
That is, but then all the matter is before the Supreme Court.
Notice is issued.
Yes, yes.
The correctness or otherwise the judgment.
Well, 1315 may not part of that.
No, but he raises MSME there also.
No, 1315 for may not. You will also make anything.
What is the trial here?
You may not loss.
What is the
Let me say something complicated.
Raises MSME there.
So that convention, that's why it's not loss. That it is a background of the earlier repetition. That's actually R4, R1A document which has produced judgment. That's the background. All those contentions have been addressed and reputation filed.
Second step is there is an SLP file would have been submitted.
That is admissible. Yes. Had I Japan matter, had I taken the SLP, the court started with that.
What to do?
What made a mistake? The only thing was in the concept of transit in the charge. I'm laying on more
What is the other expedition other than these?
I am in one petition. I stand on those. If there is a restricted area, I am out. If there is no restricted area, my petition has to be allowed. There is no dispute about my entire treatment as a person. Nothing of the sort is in existence now. The question is the earlier petitions. Now, the earlier petitions, if the process of transit in Dominica has happened, that is not the case.
Third man was the RP, you know.
I'm only one thing.
That is like it's just Dinesh.
Yes. This is where I stand on this case. The concept of transitive replica.
See, I give back the book to you to mark the questions and give it back or make a separation. Otherwise, it's difficult to read the entire book.
The melody is given separation.
Mark the questions. And also from which volume, from where you take.
And I will mark it also. The all issue is, my convention is, if there is a consonant estoppel, then I am out. If there is no consonant estoppel, then I am in. And consonant estoppel cannot happen without adjudication of some questions of fact. There cannot be a determination, there cannot be an estoppel without adjudication of facts. The court exists to adjudicate facts. And I will read this one. I conclude by referring to this. This one. Yes. We're going to pronounce it. Yes. Rasa or I don't know how to pronounce it. Yes. This is the awesome of defense. At page 295, you must go for first, one of these is going to pronounce it.
Which paragraph?
Yes. Paragraph, page 295. 295. I would accordingly dismiss the Secretary of State's appeal in etc. Then so far in this opinion, I have used the expression estoppel from replica and issue estoppel differently. But before getting to the subsidiary issues which arises in the second opinion, it is necessary to distinguish between them by reference to the careful terminology used by Nicholas J. is not a historic. He said, the particular type of estoppel relied upon by the husband is estoppel from replica. This is a generic term which is in the modern law includes two species. First species, which I will call observation estoppel, is that it prevents a party to an action from asserting or denying as against the other party the existence of a particular cause of action or non-existence of or existence of which has been determined by a court of competent jurisdiction in a previous litigation between the same party. If the cause of action was determined to exist, the judgment was given according. It is said to merge the judgment, and those who are proper values transit them to the category. So the proper merger, if a cause of action was found to be in existence on the evidence which is available, then cause of action ceased to be in existence and it was merged with the degree of effort. Unless some facts is discussed, or entitlement is discussed, there is no merger. If a question arises, whether this pen is under the Lubanos or by the court decides that it is mine, then it is the dispute, there is one order the dispute. The dispute is a dispute with evidence, but with the degree of a court, and thereafter cease to be in existence. And that process is called transitive category. And it is found to be against me, then there is nothing is merging. It's simply restricting data. So therefore, nothing is. The transitive, there is no longer way that these things can be stated except in Latin. If the observation is determined to exist, that is judgment was given upon it, it is said to be merged in the judgment. Or for those who prefer Latin, transit in the category. If it was determined not to exist, the unsuccessful plaintiff can no longer assert that it does. He is stopped by further category. This is simply an application of the rule of public policy expressed in Latin as in thermodynamic distance and equal cosa. There is no other way to say it in English. Yes. In this application of the maxim cosa, where is Latin, the plural Latin name.
Now, what is the condition with regard to the review?
I mean, in two more sentences, the second species. Now, if I cannot be ousted without a determination of facts, the court cannot make black no into white, black no just white into black. Black can be prejudice black. So therefore, there is the only option of not that the matter has to be decided on. And it has to say, I gave them the certificate all before, when they replied that the certificate notice of the section 32, I again go to their notice, and they acted contrary to the law. And suppose I know relying on the other judgments, I only rely on ambulance. Only one person is and then ambulance, only one person is otherwise is yes. Yes. Paragraph 41. Two sentences only will follow. I will conclude. 2 sentences. In paragraph 41 at page 2652.
Yes.
In middle paragraph, first paragraph, middle part. In rectifying the error, no procedure. In rectifying the error, no procedural litigation should be because no person should suffer by reason of a mistake of the court. The court has its manifest, there is directions, etc. If no rule of procedure would apply to prevent the court from entertaining the mechanism and giving appropriate direction. In this connection, etc., that's it. The High Court reserved that no act of a court or irregularity can come in the way of justice being done. And one of the highest and the first duty of all courts is to take care of the fact, to take care that the act of the court does not injure, does no injury in the supreme. And they get about paragraph 42, second part, yes. Perigure are those decisions given in ignorance or forgetfulness or some inconsistent statutory provision or some authority binding on the court counsel, so that in such cases some part of the decision or some step in the reasoning on which the decision is based is found on that account to be demonstrably wrong. As cannot I take your worship to this paragraph 47.
You already read it, I already marked it.
Yes. That one sentence for this. So paragraph 48, one sentence.
Those texts you just marked it.
It is one sentence. It can do so in exercise and incorrect jurisdiction in any proceedings pending before it without insisting on the formalities and the way of it. Power of review can be exercised in the condition of Article 136 or Article 132 or any other provision of the Constitution. If the court is satisfied that the direction, etc., violation of the provision of fundamental rights, etc. Yes. Then the court again, yes. One more sentence, yes. For paragraph.
You already said 7 sentences after saying one more sentence.
Yes.
Now, what do you have to say in the review?
So, the same connection.
No, there after that you file a repetition, you suffered a judgment. Now we are asking for a review of the judgment which is considered in the second repetition.
The review will die if there is a justificator. If there is a justificator, no review will die.
No. In that case, your difficulty will be to rely on and a separate judgment passed thereafter, which is not challenged. That also my feeling is that. I don't know if my friend has again directly true directly, but other law. Parts in the rule of every other day you file, you will not be doing.
Only the auto worker, this connection has to be made by Supreme Court only. because the other two only can be corrected with them.
You have succeeded 50% in second judgment.
Other matters are coming. Other petitions are coming. Look at the finish. Ask me are there. Undeniable. So that's one. Then one way I say arose the paragraph 50. If that was so, when the attention of the court is drawn, the court has always the power and the obligation to correct it ex tempore justitia and treat the second application by his inherent power as a power of review to correct the original mistake. May I repeat, fellow? Obligation to correct it ex tempore justitia and treat the second application by his inherent power as a power of review to correct the original mistake. No sooner should suffer for all of the court. And I conclude. No sooner shall suffer for the law of the court.
No, can I add one? Similar to the law, SLP will not be barred to decide with 1315. So, SLP is regarding WTC 3298 and which has been filed earlier. So, in this present regulation, as I pointed out, also fact is on the basis of the option of the court order. Since that option has already been conducted and he has already accepted the same, like more is to say, and as long as that does not form part of the security of the MSME loan available, my lord can decide 1315 independently. Because this SLP, whatever they it's not a bar, that is pertaining to all those conditions can be let off because that is what actually the RBI judgment is produced. Your law making entity is suppressing those two things is fine.
Hey, just 2 minutes. Now, my friend had taken the conduct of a 25 crore limitation in the petition, original petition, which was found against him, in which he filed a writ appeal. The grounds have passed on that. But the division bench considered that also, recorded that this was a contention there, and then held against him. Against which he filed a review petition, he went to SLP, then on dismissal SP, RP was filed. RP also, I will pass on a copy later, but RP also does not have a ground. So, as far as that ground is concerned, he is fine. Now, may I just read out a couple of paragraphs of from Celia. I know, I not must have thinking about it in your sleep, but then
Which paragraph?
141 onwards, yes. I marked that. Thing. In fact, I'll just go to the last one. I don't want to burden my lord in the evening, except 141 onwards. Just 2 paragraphs. The Henderson principle was approvingly referred to and applied by this court in this court in state of UP, etc. As the underlying principle for res judicata and constructive res judicata for assuming finality litigation. The relevant observations as under. The principle of estoppel per rem judicatum is a rule of evidence, as it has been stated in Marginson, etc. It may be said that to be the broader rule of evidence prohibits reassertion of a cause of action. This doctrine is based on 2 theories: the finality and conclusiveness of judicial decisions for the final termination of disputes in general interest of the community as a matter of public policy, and the interest of the individual that he should not be protected from multiplication of litigation. It therefore it therefore serves not only a public but also a private purpose by obstructing the reopening of matters which have once been adjudicated upon. It is thus not permissible to obtain a second judgment for the same civil relief on the same cause of action, for otherwise the spirit of contentiousness may give right to conflicting judgments of equal authority. The next paragraph. But it may be that the same set of facts may give rise to 2 or more cause of action. If in such a case, the person is allowed to choose and sue upon one cause of action at one time and to reserve the other for subsequent litigation, that would aggravate the burden of litigation. Courts have therefore treated such course of action as an abuse of its process, and Somerville, etc., and has answered it in the following as follows. I think on the authorities to which I will refer, it would be accurate to say that res judicata for this purpose is not confined to the issues which the court is actually asked to decide, but that it covers issues or facts which are so clearly part of the subject matter of the litigation and so clearly could have been raised that it would be an abusive process of the court to allow a new proceeding to be started in respect of them. This is therefore another and equally necessary and efficacious aspect of the same principle, for it helps in raising the bar of the adjudicator by suitably construing the general principle of subduing a cantankerous litigant. That is why this other rule has sometimes been referred to as a constructive adjudicator, which in reality is an aspect of application of general principle. So if you gone beyond the rules of general, no, I'm not reading, I just highlighted another paragraph. I don't want to burden my lord late in this day. So what I'm saying is, once he has raised, it is found against him, he abandoned that, despite the fact that the division bench considered that. He went to SLP, dismissed, came back and RP dismissed. Now this court cannot consider this, that's my humble submission.
Short point. Just four short points. Firstly, my lordship, my review petition is a delay of 197 days. 197 days. I filed a counter to that review petition. In paragraph, the counter is based on my lord, I benchmarked the case. Paragraph 2 of that counter, my lord, I have given the timeline. Paragraph 2 of my counter page. I've given the timeline. The judgment sought to be reviewed was pronounced on 22/11/2024. My lord, immediately thereafter, my lord, next petition has been filed on 26/11/2024. 5 days thereafter. A claim benefit of MSB submitted that on 22/24, the review petition filed contempt petition 3404/2024 against Officer Bank alleging contempt. Thereafter, while the said petition was pending, review petition filed WPC so on 1/2/2025 challenging security measures initiated under section 14 and claim benefit to MSMEs. And thereafter, my lord, on 28 to another writ petition is filed. My lordship's judgment comes on 28th July, my lord. And the SLP that they had filed was 28th April. My lord, the only ground that is stated in the condemnation for delay, my lord, is that due to personal health reasons, they could not contact me. My lord, so much of litigation has occurred during that period, my lord, and therefore the delay itself, my lord, there's no sufficient explanation. Secondly, my lord, the judgment under review. Very clearly found that, my lord, that the petitioners, my lordship, comes to page 28 of the paper book, RP paper book. That is on merit. That's on merit. Page 28, paragraph 26 of the judgment sought to be reviewed. Yes. So the facts stated about the evidence that the petitioners have filed one after another petition before this court filed one after another petition before this court and did not comply with the interim order, final order, and their own undertakings. The petitioner never raised the issue of petitioner being MSME and allowed the person of the SLP Act to take it without such a plea in the first instance. The petitioner had not disclosed the final report of this petition and they have disclosed the material facts. Etc. Matter the court goes on to find. My lordship may kindly see the judgment of my lord sister, my lord, which is passed on 28th July. There, my lord, after holding, my lord, that the plea is held as, my lord, falls within the ambit of res judicata, my lord. My lordship, at paragraph 30, paragraph 40, my lord, that is bottom of the page numbering at page 18. Paragraph 40. My lordship enters a finding on merits. Even on merits, the conditions of petition MSME registration obtained prior to NPA classification automatically entitles them to protection to the notification that 29/5/2015 is legally untenable. As held by the Honorable Supreme Court, so it is the obligation of the borrower to disclose its MSME schedule with authenticate and verifiable documents for the loan account is classified as info and failure to do so disentitles the borrower from enforcing the statutory framework regulated in case of under the lordship and thereafter. My lordship, at paragraph 41, again states, my lord, that at the bottom,
the petitioner's contentions after the last few lines, the petitioner's contentions cannot be accepted, even the judgment suffered by the petitioner, including in WPC, since the judgment got to review. And so, my lordship, they entered a plea on merits, entered a finding on merits also. And this judgment is not sought to be reviewed, or my lords, there is no challenge as to this judgment. My lord, furthermore, my lord, as we have stated, my lord, as point 3, that they had filed an SLP against this, which was not, also, my lord, in my counter, stated that so that is suppressed. So the RP is suppressed. I mentioned in the. Correct, that my lordship has, but the RP, my point, my lord, is the RP is suppressed. A. B, my lord, those the pleadings have taken a legal condition of merger, my lord, but because of Punjabat, my lord, because the SLP stage and the court has only stated that he has heard the matter at length, etc. So that I'm not specific. Lastly, my lord, on the very specific aspect of the ambit of review jurisdiction, my lord, for an appellate power of the court, a recent judgment of this court, judgment of the Honorable Supreme Court. Lord, Malaysia was Sugna, my lord, 8 September 2025. My lordship, at paragraph 15, the page numbering at the bottom, my lord, internal page 4. Very crisply, paragraph 15. In summing up the In summing up the precedents on the point, the judgment may not be understood as though we are putting an old spin on a classic. The court notes that there is no informative or illegality in retaining the review petition. However, the approach to the error pointed out warrants the review of the precedents on the point. It's axiomatic that the right to appeal cannot be assumed unless expressly conferred by statute or the rules having the force of the statute. The review jurisdiction cannot be assumed unless it's conferred by law on the authority of the court. Section 114 order particular movement of the Code of Civil Procedure deals with power of review of the court. The power of review is different from appellate power and is subject to the following limitations to maintain the finality of judicial. The review proceedings are not by way of an appeal and have to be strictly confined to scope and ambit of order particular movement of the Code of Civil Procedure. Review is not to be confused with appellate powers, which may enable an appellate court to correct all manners of errors committed by the subordinate court. In exercise of the jurisdiction under order particular Order 47, Rule 1 of the Code of Civil Procedure, it is not permissible for erroneous decision to be heard and corrected. A review petition is thus remembered as a limited purpose and cannot be allowed to be an appeal and right? Or an erroneous decision to be heard and corrected. No, in terms of an error of, it should be, my lord, for the error occurrence of the case. It is not permissible for an erroneous decision to be heard and corrected. Yes. Not an alleged. Correct. But whether the way it's been done or very quickly, the citations are all shifted to the footnotes. So the easy discussion. The power of review can be exercised for the correction of a mistake, but not to substitute a view. Such powers can be exercised in the limits specified in statute governing the exercise of power. The review court does not set an appeal over its own order. But if the review court finds that it is erroneous, 100% is correct. If it is error occurring on the face of the record, that's what. It cannot be, my lord, as my friend has personally argued, my lord, after 2 days of argument and detailed reasoning, no. Here, the petitioner would allege that it is erroneous. Yes. Not that it is correct. Until, my lord, for that matter, my lordship sees the facts convey. The judgment of the Honorable Supreme Court in the first instance was, my lord, had the effect of depriving the litigant of a forum of intra-court appeals. In the context of criminal trial. My lord, 62 to throw a review application apparent error of fact or law is intimated to the court, but no extra reasoning is undertaken to explain the said error. The intimation of error at the first blush enables the court to correct apparent errors instead of the higher court correcting such errors. At both of those cases, detailed reasoning is not warranted. Having noted the distinction between the power of review and appellate power, we restate the power and scope of review jurisdiction. Review grounds are summed up as follows. That the ground of discovery of new and important matter or evidence is the ground available. It is demonstrated that despite the excess of due diligence, the evidence was not within their knowledge or could not be produced by the case where the review was allowed but reversed. My lordship is referring to the ultimate. No, this case, yes, the review is allowed. Yes, the Supreme Court finds it wrong. Yes. Yes. You know, the mistake of 70.2 mistake error apparent on the face of record may be invoked. if there's something more than a mere error, it must be the one which manifests in the face of record. Such error may is a great error and not a mere wrong decision. Error which has to be established by a long-term process of these points, but they may continue to be two opinions can hardly be said to be an error apparent in the face of record. Lastly, the phrase for any sufficient reason means the first reason that is sufficient on grounds that is analogous to those specified in the other two categories. That comes from NCT Delhi versus Article. Yes. Well, of course, not to mix up or overlap one jurisdiction with another jurisdiction, having moved the appellate and review jurisdiction of the court, we will apply this principle to execute order. One more short submission, my lord. An IA had been filed today with us. IA number 1 of 2025 was receiving additional document. I presume, my lord, the intention of that is to bring new facts on record in the RP. But, my lord, the same document was filed, my lord, in IA number 1 of 2025 in WPC 420503. That is, my lordship, already that judgment had come. So this is not new facts or new documents. That's my only point. And IA has been filed for receiving additional documents. This IA corresponds to the IA 1 of 2025 in WPC. Even on that ground, my lord. These documents were produced in IA number 1 of 2025 in WPC 42050 of 2020.
Very briefly, I did not visit the lines of the time. I have not been in France. Yes. And there are now, how function into reality. This is a case. It's a case where not a single bank or financial institution in this country has given a written notification. It came in the 2015.
You said that I noticed it.
Yes, therefore, this is an extraordinary case. I look at the way
I saw that you noticed it.
Madras High Court has said, yes, the youth will record the court is called the Getting Heart is recording the fact that past not act like a child of pound of flesh. Then that is in paragraph 20. I am not reading it. Paragraph 20, 19 ending with the verse. Yes. Yeah, yes. The paragraph 19. The timing of the was just taking paragraph 19. Yes. Yes. Last this court is on the considered opinion. Paragraph 19. This court is a considered opinion that the scheme has fixed a duty on the bank's consular community, a duty to formulate a scheme for revival, and also shall incorporate the cause of development, etc. While the party is so claiming the MSME unit that the claim is clearly accepted and not be accepted. So who it is like the case of the calling the they are called. Why you have to come 1,000 times? Because whatever was entitled was denied. They filed an affidavit. They filed an affidavit against the statute that the Madras High Court has taken compulsory. They have said the bank has filed an affidavit against the statute.
I'll consider that.
Against the statutory claim.
I'll consider that.
Yes, therefore, here is a case. Now, surrounding. See, this is an extraordinary case. And one way my friend alone, this is Nariman's question. Paragraph 34.2. Only one way I say, really. Paragraph 34.22. Only one way.
Which judgment?
This is Nariman's question.
2018.
Yes, only one way. 34.2. An issue of law will arise between the same parties in a subsequent suit for proceeding is not proceeding carried out. Given the erroneous decision, given on a statutory prohibition, the former suit for proceeding, the statutory prohibition is not given as a truth. That's one word is enough. There is no extraordinary statutory provision. I'm reading it once again as an last sentence. I'm reading it again. An issue of law which arises between the same parties in a subsequent suit or proceeding is not proceeding character if by an erroneous decision given on a statutory prohibition in the former suit or proceedings, The statutory prohibition is not given effect to. There's a statutory prohibition not to classify by award as NPA. And with all the previous evidence is it can be done. I'm seeking correction. No, nothing on facts. Only a correction or a wisdom law.
The books which are given only give the relevant pages, mark it and give. The front sheet should show which book you are like.
And one point that I will only the logic is passed. So this will be effective. It will always come.
From today till a pronounced judgment, don't do anything.
5:30. Can it be next?
It will come tomorrow.
Next week?
Please inform the other side.
Yes, he is careful.
By 13, you want it next week.
Next week.
You want it next week.
Next week. Top of the list.
Next week.
I'll give everything by tomorrow. Without everything else to do.
I'll pronounce it judgment in 10 days time.
Yes.
Don't put
No, that I'll undertake, no
Just
problem.
one, my matter was the say not that we issue, but it's only the second week of October, my matter the sale is scheduled. So nothing.
Yes, not
And my idea is not for additional, production of additional.
Good, otherwise I have to dismiss it.
I think my friend has filed an IF pleading. My friend has filed an IF pleading in that.
Yes,
That may be allowed because
Which case?
in that Esteban that is 32541. LRs. MD Esteban died. So to implead LRs, that may be allowed. So I have not got a copy, I just found it online. It may be allowed. Thank you.
He had moved 25 alone. This is that thing, it should be changing the words.
And IA1 is, I'm sorry. IA1 and IA1 additional documents are